Vastola.
Well, good morning, everybody, and thank you so much for tuning in to Vastola on the Law. You just heard the number to call in. If you're listening on the radio this morning, dial 877-850-8585. That number is going to get you into the studio. Our board operator, VJ, good morning, VJ. He will take your phone call, get your name, put you live on the air with me, and you can ask me anything that you want. If I can answer your question right here, right now, then that's exactly what I'll do. If I don't know the answer to your question, or if I feel like I need to spend a little bit more time on the issue, then I will research the topic and get back to you the following week with what I consider to be an educated response to the question. Last week, Harold called with a question about how he and his wife should own their rental properties. And just coincidentally, this was a topic that I had discussed a few weeks before. So finding the information was not that difficult, but I didn't retain it in time, or long enough, I should say, to be able to respond to Harold in an educated way. So I have that information again at my fingertips today, so I'll be responding to Harold's question in just a few minutes. Hopefully you're listening, Harold. This show is brought to you by my law firm, Vastola Legal. I am Jeff Vastola. I'm an attorney in Florida, and this year will be my 25th year as a lawyer. I just did that math yesterday sitting at my desk because I couldn't believe that it's actually been 25 years. But I have offices in Stuart on the Treasure Coast and one down in Palm Beach Gardens in Palm Beach County. And we represent clients throughout the state for various reasons. We handle in my office personal injury and wrongful death claims. So in the event that you feel you may have one of those claims and you want to talk to me, you can call me. And of course, the consultation is always free. But you can contact me 24/7 by dialing 833-VASTOLA. Now, that's not the number to call in the next 30 minutes while I'm on the air. That's the number to call at any other time, whether it's on the weekend, whether it's at night. I encourage people to use that number. It forwards to my cell phone. So if you have anything to talk to me about in the way of a potential case, then call me at 833-VASTOLA, and I'll be happy to give you my honest opinion as to whether I think you have a case or if you don't. And I know I've heard frustration from folks in the past that when a case is declined, sometimes they're not given a real good explanation as to why. Sometimes they're given no explanation as to why. If you take the time to call me and fill me in on the details of your case, and if I feel as though it's not worth pursuing for any given reason, I will tell you why. I don't mind doing that. Even if you think you have a case that's been declined by other lawyers in the past, I still encourage you to give me a call because, first of all, if there is no case, you should know why. And secondly, in the past, I've found that I have been able to pursue claims that had been declined by other lawyers in the past. Not to suggest that I'm any better than them, but a fresh look can sometimes help. So if you'd like to talk to me off the air, the number is 833-VASTOLA. That number is also available to anybody that has a radio show type question, but the facts may be too personal to share on the air, and I understand that. That does happen too. So if you call me to discuss something that's not within my ambit of law, then I may certainly spend the time to talk to you, but might then address the issue on the radio show by keeping everything generic, not using any names, but just to talk about the issues, because sometimes other people benefit from your issue, whatever it may be. Today I'm going to be talking about the different ways to title real estate in the state of Florida. I'll remind everybody I'm only licensed in the state of Florida, so the Florida Bar only allows me to give legal advice for the state of Florida. So all of my research is typically geared towards Florida. Now, I will tell you that there's another topic on tap for today, which I kind of brought up on my own, but it was a segue from my cousin Julie's question from a few weeks ago now, where she had asked what the cost would be to start up a charitable foundation. So I looked into that federal statute. It's the federal code is 501. And just because I was more curious than anything as to how many different subsections of a 501c are there, and I looked, and from what I saw, there are 29 different varieties of a non-taxable type of organization. And so ordinarily, I think most lay people, when they hear 501c, the next thing they say is 501c3. That's what most of us have heard of. It's, I think, clearly the most common type of nonprofit organization that exists. But there are, in fact, 29 different variations of 501c's out there, from 501c1 to 501c29. So if anybody's interested, you can, of course, find that same federal statute by going to the internet and just typing in federal code or federal statute 501, and the whole thing pops up. Not always the easiest stuff to read, federal statutes, but I'm sure you'll do just fine. So I want to thank everybody again in the event that you haven't been watching my show in the last couple of weeks. My father did pass away at the end of December. We miss him dearly, but for all of you that typed in comments and prayers, and those of you that called, and those of you that texted, and those of you that sent flowers and everything, we really appreciate that. Every day is a little bit easier. We're confident that Dad's playing golf in heaven right now. But just a thank you, a sincere thank you again to everybody. We really appreciate it. So let me jump into my first topic. But remember, the number to call into the show, because I'll emphasize this again, I prefer your phone calls over my topics. Now, I'm going to address Harold's question from last week because that's the way I do it here on the show. But I do want you to call in with a question of your own. So the number to call is 877-850-8585. And again, remember, this show is brought to you by my law firm. It's sponsored by my law firm, which means my law firm pays for this time. So in the event that you have a case that you might want to talk to me about, you can call me privately at 833-VASTOLA. 4 different ways to own real estate in the state of Florida. Generally speaking, it's tenants in common, joint tenancy, joint tenants with right of survivorship, which is a variation of joint tenancy, and then number 4 is tenancy by the entireties. So the short answer to your question, Harold, if you're listening or if you're watching, is the best way, in my opinion, to own real estate in the state of Florida, especially if it's a investment property and you own it with your wife, is tenancy by the entireties, hands down. Because tenancy by the entireties, first of all, is the only way that you can own property jointly with your wife. It's the only one that you would qualify for as a married couple. It's the only one that allows you the benefits of asset protection because you're a married couple. The other ones wouldn't give you that same protection. And so, in my opinion, that's just how I'm bent, I suppose, is, you know, how should you own your assets to protect them? And tenancy by the entireties specifically gives you that protection because a creditor of one spouse cannot attach or go after, try to, collect by foreclosing the property to pay off a judgment that a creditor may have against just one spouse. And if that doesn't make sense to you, you have to understand there are situations where perhaps only one spouse is going to be sued for any given reason. It could be because of a car accident. It could be because of professional liability. It could be because of a credit card debt that wasn't paid. It could be for any number of reasons that perhaps only one of the two spouses is sued. If you have just a hypothetical Capital One credit card versus John Doe, because John didn't pay his credit card debt, but John is the only one on the card, but John is married to Jane Doe. When Capital One sues John Doe, Capital One could get a judgment against John. If John and Jane Doe own their properties as tenancy by the entireties, then even if Capital One gets a judgment against John Doe, it would not be able to foreclose the property that's owned jointly with his wife because of the protections of this tenancy by the entirety. And so, for that reason, in my opinion, Harold, the best way to own your rental properties with your wife is by tenancy by the entireties. There are other ways to own real estate, and there are benefits and detriments to each. And so, again, the other 3 are the joint tenancy with a right of survivorship, a standard joint tenancy, and then a tenancy in common. Just very quickly, so that you know the difference between the two. A tenancy in common is almost the opposite of the tenancy by the entireties. Remember, tenancy by the entireties is real estate that can be owned by a married couple. Tenancy in common is when real estate is owned by two or more individuals who are not married to each other. Each tenant in a tenancy in common may pass the interest, his or her interest in the property via a will to whoever they want. So if you end up going into a property ownership situation with somebody that you like, understand that if that person passes away and bequeaths his or her interest to somebody else that you don't like, you might end up owning property with somebody that you don't like. That's one of the detriments to a tenancy in common. Let me see. Another disadvantage of that is that this form of ownership may also lead to one tenant's creditor levying or ultimately foreclosing on a tenant's undivided interest to satisfy a debt owed. So not only might you end up with a property partner that you don't necessarily care for, or perhaps you don't even know, but if, even without considering death, if your partner in real estate should go get himself into financial trouble and a creditor comes along and sues him and gets a judgment, that partner's interest in the real estate is subject to collection by the creditor. So you could end up being a partner in real estate with somebody that you really don't know, because if it's a bank that acquires that interest, they're of course going to put it on the market and try to sell it to somebody, and who knows? I mean, I suppose you could always try to buy it, but you also may end up being a partner of somebody that you've never even heard of in your life. Joint tenancy with right of survivorship. This is often used, according to what I'm reading, amongst family, and they are the intent is to keep the property ownership within the family, not married couples, but family members. So when one of these owners passes away, the tenant's rights pass to the other joint tenants. So if you have 4 family members that own a piece of property and one of them pass away, automatically the other 3 earn the deceased party's interest. So that's how that one works. There is a catch here that Florida is considered a lien theory state, and so one joint tenant can mortgage his or her interest in the property, and that can effectively destroy the joint tenancy that was created by everybody. So keep that in mind as well. It's one of these things where there's pros and cons to each one of these things. Again, in my opinion, the no-brainer here is if you are a married couple and you're owning property for investment purposes, or even if not, even if it's just your main property, own it as tenancy by the entirety, because you get that creditor protection. But all things considered, there are benefits and detriments to each, so you have to weigh them on your own and decide which one is best for you. In my notes, I go on to talk about 26 U.S. Code Section 501. This is where everyone has heard of the 501c3 designation. This is where it comes from. It comes from a federal statute, which is also referred to as a U.S. Code. Again, it's 26 U.S. Code Section 501. It's entitled Exemption from Tax on Corporations, Certain Trusts, etc. So it doesn't have to be a company, by the way. It's a lot of these are trusts that are set up. And if you're interested, what 501A and 501B may be, 501A says exemption from taxation. This is really the purpose of this particular law. An organization described in subsection C or D, or section 401A, shall be exempt from taxation under this subtitle unless such exemption is denied under section 502 or 503. So that's the main reason people do it, because they're exempt from taxation. So it's been quiet so far. Good morning, Delita. Nice to see you this morning. Hope everything is going well over at Matrix. So if you'd like to call into the show, let me remind you of the number. It's 877-850-8585. That's the number to call in. You can be live on the air with me. You can ask me anything you want. The only thing I ask is that we don't go political. That's a bad place to go these days. But on the radio from 7:30 to 8 o'clock on Saturday mornings, I do not limit questions to personal injury and wrongful death because that's what I do during the week. I kind of expose myself to any question at all, and when I don't know the answer, I will research the issue and get back to you the following week. And don't be shy. If you have something going on and you're embarrassed, or you think that the neighbor that you want to complain about is going to find out that you're talking about that person on the air, change the names. You can change your name. You can change the names of the people involved. I frankly would request that you don't give us the name of other people involved because I don't want any hate mail. But do what you need to do to call into the show and make the show interesting for everybody. And I would encourage anybody to call in, even if it's just a comment. So 877-850-8585. I did want to mention this because I was asked, what do you think separates you from other law firms? I will say this. There are a lot of different ways to practice law. What we learn in law school is that, of course, no matter what you do, you always have to be ethical. You have to follow the Florida Bar's ethical guidelines. But you can apply your own moral code as long as that doesn't deviate from Florida's ethical guidelines. There are a lot of different law firms, a lot of fantastic law firms, some big, some small, and then everything in between. The focus of my practice, and I don't want to say that I'm doing it better than anybody else, this is the focus of my practice, is to stay small and to be able to give personal attention to those that want to hire me and those that I feel have a case that's worth pursuing.
Hey, Jeff.
Yes.
We have Robert from Fort Lauderdale.
Great. Thanks, VJ. Let's talk to Robert from Fort Lauderdale. Robert, whenever you're ready, go ahead and tell me what's your question.
I am ready. I have a son. He's in early years. He got some run with the law. He's got a record. He's having the hardest time finding decent work, and don't know what to do.
All right. Well, I appreciate you calling in, and I'm not real familiar with the issues of where people can work once they've had problems with the law, efforts that the state makes to help them get reemployed. But it's a pretty general question. But what I'm going to do is I'm going to do the best I can with it. So now let me ask you some questions, just because I think there might be some issues that I'm going to stumble across almost immediately. Was your son convicted?
I think one of them, he had a few of them misdemeanors, and I believe one of them he was convicted.
Okay. Well, that was kind of my next question was it a felony or a misdemeanor for what he was convicted?
I think one of them, the main one would be a felony. The other one's a misdemeanor. This is when he was younger.
Okay.
Nutty.
And
he's pretty straight now. But as far as decent work, whenever I look up his record, he's shooting down all the time.
Okay, and I understand. This is obviously very personal and perhaps private to your son. Don't give me your son's name and don't give me your last name. But what was the crime, the felony crime?
He pulled over a felony. He had some drugs with him.
I'm sorry. Did you say drugs on him?
And yes, in the car he had some drugs.
Okay. All right. Well, let me just share this with you, because this comes up all the time when I interview somebody who wants to hire me for a personal injury or a wrongful death claim. One of the first questions on my interview form, after I get the date of the accident and all the demographic information from a person as far as their address and social security number, is, have you ever been arrested for anything? And the reason I ask my question in such a very broad form is because there are some arrests that concern me as a personal injury lawyer, And then again, there are some arrests that don't. I don't ask the question to be judgmental of anybody. I ask the question because some arrests are admissible in a jury trial, even though they happened in the past. But then again, some of them are not. The Florida Rules of Evidence are there to suggest that anything that's relevant can be admissible. So again, there are always reasons to try to exclude a conviction history or a plea history, but generally speaking, crimes of dishonesty are the arrest history that concern me, because oftentimes in a personal injury trial or a wrongful death or medical malpractice trial, when somebody has been arrested for writing a bad check or stealing somebody's identity or stealing somebody's car or defrauding the elderly, all of these different types of crimes that are considered crimes of dishonesty, those can possibly be admissible in a jury trial for personal injury, believe it or not. And so that's why those arrests concern me. Now, you're telling me that, your son's having a hard time getting a job because of a felony and some misdemeanor convictions, and the biggie was drugs. I know this is not what you're asking me, Robert, but I'm kind of sharing this for your own edification. If your son was trying to hire me for a personal injury case, that's not the kind of arrest that's going to concern me, because someone being arrested for drugs is not very likely going to be admissible in a personal injury case. The point is, if your son was arrested, if he was convicted or pled to some kind of a plea arrangement, but he's done his time, so to speak, then hopefully, that won't be something that follows him around for the rest of his life. I know that there are organizations out there that are willing to give people a fresh start, and that's what I'm going to research for you, Robert. So next week, just tune in, because I'm going to give you my answer next week live on the air. But also, if you happen to miss the show, yeah, no problem. And if you have any follow-up, feel free to ask me now. But if not, you can hang up and get on with your Saturday morning.
Yeah, well, things they are pretty hard right now with the record. It's a lot harder.
Yeah. Well, with COVID, I'm sure, there's not as many people hiring now as maybe there would have been. But let me see what I can find for you to help out your son, okay?
I'll be listening.
Thanks, Robert. So, as I was going to say, if you happen to miss the show and you really wanted to know what I had to say about a specific question that was asked a week prior, you can go to several different places to find it. You can find my show uploaded to my YouTube channel. You can find my show uploaded in an iPod format to my website, which is vastolalegal.com. So that's pretty easy to find. And you can also go to Facebook. You can go to Facebook. If I'm your Facebook friend, then you should be able to find my show in your news feed. You may have to scroll down quite a ways depending on how many friends you have. But you can always find it there. I think you could probably do a search and find it relatively easily. And if you're not a Facebook friend of mine, but you'd like to be, then request me as a friend. As I mentioned last week, I'm getting friend requests from people that I don't recognize, and I don't typically accept them. If that's you, because you've been trying to become a Facebook friend of mine because you listen on the radio, and I'm just not accepting your friend request, then call me and say, hey Jeff, I listened to you on the radio. I'd love to be a Facebook friend of yours so I can watch you on Facebook Live. Then let me know that, because otherwise, like I think most people, I don't accept every friend request that comes through. I've heard, the stories like everybody else about why sometimes people friend request you, and so I really tend to like to know who it is before I accept the friend request. But nowadays, since I'm using Facebook Live, I want to have as many friends available to watch as possible. So, Florida Law Weekly. Let me see. We've got, oh boy. VJ, am I out of time already?
No, you got about 2 minutes left.
2 minutes left. Okay, so I love to talk about my Florida Law Weekly. I know when I watch the show, because I do watch the shows afterwards to see how I might be able to do things differently or improve my show, I do notice that this comes up backwards, so I apologize for that. But it's Florida Law Weekly. It's a publication. You can get it. If you're a law nerd like me, and you want the Florida Law Weekly so you can see all the cases that are published by our district courts of appeal and the Florida Supreme Court every week, then just subscribe and they will send it to you. It comes in the mail. It's great. There was a case in here that I wanted to talk about, and it's interesting because I was just talking about the admissibility of prior convictions. Well, this talks about the admissibility of a plaintiff in a personal injury case being intoxicated. And this is a case of Ernest Balo versus ABC Liquors and a guy named Paul Matthew Mullins. This is out of the first DCA, which is up in the Tallahassee area. The plaintiff, thank you, VJ, brought a personal injury lawsuit. He lost at trial because the defense was allowed to introduce evidence of the fact that he was drunk at the time that he was hit on the side of the road. And for those of you that don't know, Florida law has a provision that says if you are intoxicated and if that plays a significant role in how or why you got injured, then you don't recover. If anybody has any questions at all about today's show, call me, 833-VASTOLA, 24/7. You can reach me. Leave me a voicemail message if I don't answer. And thank you all for listening. God bless everybody. Have a great weekend. Take care.